The two lobby groups moved to the Court of Appeal under a certificate of urgency, seeking to have the High Court's decision on the election date stayed until the appeal is heard and determined. They argue that elections should not be held later than 14th October this year. This, they contend, is in line with Section 9, subsection 1 of the 6th schedule, which states that elections should be held within 60 days after the dissolution of Parliament.
The last possible date for the first general election under the new constitution will be or should be the 14th of October 2012.
The applicants contend that the High Court made a mistake by leaving it to the executive to determine the election date.
There was a miscalculation by the High Court as to when the date of the next general elections in Kenya will be.
According to the two lobby groups, it was wrong for the High Court to purport to amend the Constitution by giving the President and the Prime Minister the power to determine or have a say in the date of the next general election under the new Constitution. They therefore want an interim order staying the High Court's decision until the appeal is heard and determined. The applicants who did not take part in the High Court case argue they are affected by the decision and are appealing against it in the national and public interest.
We want certainty because we understand that elections are a very fertile ground for conflict. We saw that in the last general elections. And if we do not have certainty and a definite date, then we are likely to end up in a crisis like we did.
On the 13th of this month, a three-judge bench ruled that elections should be held in 2012 within 60 days from the date on which the national coalition is dissolved by written agreement between the President and the Prime Minister, or upon the expiry of the term of the 10th Parliament on the first Saturday of its 5th anniversary.